Greetings teachers and staff members. Today I will be presenting on the search procedures in schools. Understanding the legal framework and best practices. Search and seizure. School staff can search students' lockers or personal belongings if they have reasonable suspicion that the students have illegal items or are violating school policy. Most searches in schools involve finding illegal drugs or weapons. The Fourth Amendment. Students claim that searches conducted by school officials without a warrant violate their rights under the Fourth Amendment of the U.S. Constitution. The Fourth Amendment aims to protect individuals' privacy and security from unjust intrusions by government officials. It safeguards individuals from unreasonable searches by mandating that state agents, usually law enforcement officers, must obtain a warrant supported by probable cause before conducting a search. Application of the Fourth Amendment to students. Because Fourth Amendment protections only apply to searches conducted by state agents. A key issue in education cases is whether school authorities function as private individuals or state agents. New Jersey v. T.L.O. In New Jersey v. TLO, a 14-year-old student was caught smoking in a school bathroom. Assistant Vice Principal Theodore Choplick searched her purse, finding cigarettes, marijuana, and evidence of drug dealing. TLO was charged with juvenile delinquency and sought to suppress the evidence, claiming the search violated her Fourth Amendment rights. The initial court upheld the search, but the New Jersey Supreme Court found it unreasonable. The U.S. Supreme Court then agreed to review the case. Ruling in 1985, the Supreme Court ruled in New Jersey v. TLO that public school officials are considered state agents, and all governmental actions, including those of school officials, must comply with the constraints of the Fourth Amendment. The court in TLO concluded that even though the Fourth Amendment applies, educators' significant interest in maintaining discipline necessitated relaxation of the warrant and probable cause requirements imposed on police officers. The court reasoned that requiring educators to obtain a warrant before searching students suspected of violating school rules or criminal laws would disrupt the administration of timely and informal disciplinary procedures required to maintain order. Court held that the legality of a search should depend on simply the reasonableness, under all the circumstances, of the search. The standard for school officials remains reasonable suspicion. When considering the reasonableness of a search, the court in TLO established two tests. 1. Is the search justified at its beginning? In other words, are there reasonable grounds to suspect that the search will uncover evidence indicating that the student has violated a school rule or the law? 2. Is the scope of the search reasonable? This means that the type of search should be relevant to the objective of the search and should not be excessively intrusive, taking into account the age and sex of the student and the nature of the infraction. Factors for reasonable grounds: child's age, history, and record. Seriousness and prevalence of the problem. Exigency of the situation. Reliability of information. School officials' experience with the issue. Lawful proceedings for searches. Students should not expect privacy in lockers, desks, parking lots, other school property or equipment owned or controlled by the school, or their personal property in any of the areas above. Schools can have police, including dogs, help in the searches of these areas. They could check for illegal drugs, weapons, or other illegal or dangerous materials or substances. Outside of the areas above, a school can search when they have reasonable suspicion of a violation of the law or school rules. Lawful proceedings for searches. To do a strip search of a student, the school usually needs suspicion that a student has committed a specific crime or violation. The contraband is concealed on their person, and the item presents a clear danger, like weapons. If the school finds evidence that a student violated the law or school policy, the evidence may be retained. The school may take disciplinary action, and the evidence can be given to the police. Metal detectors. Metal detectors are commonly used in airports and public buildings, and people are used to going through them. Even though using them is considered a search for Fourth Amendment purposes, courts have ruled that schools are allowed to use metal detectors. The general scanning of students with metal detectors is only minimally intrusive on students' expectation of privacy when weighed against school officials' interest in providing a safe school environment. Illinois statutes. Illinois compiled statutes 105-5-10-20.14. Student discipline policies. Parent-Teacher Advisory Committee. The school board or governing body of a charter school is required to establish and maintain a parent-teacher advisory committee to develop policy guidelines on pupil discipline, including school searches and bullying prevention. This policy must be provided to parents or guardians within 15 days of the beginning of the school year or within 15 days for a pupil who transfers into the district during the school year. The school must also inform its pupils about the policy. Additionally, school boards, governing bodies of charter schools, and the Parent-Teacher Advisory Committee must annually review their pupil discipline policies, their implementation, and other factors related to school, pupil, and staff safety. Illinois compiled statutes 105-5-10-22-10A. Inspection for drugs. School boards have the authority to establish a policy allowing school officials to seek help from law enforcement for conducting reasonable searches of school grounds and lockers for illegal drugs. This includes searches using specially trained dogs. Illinois compiled statutes 105-5-10-22.6 Suspension of expulsion of pupils, school searches. To maintain order and security in the schools, school authorities are allowed to inspect and search places and areas such as lockers, desks, parking lots, and other school property and equipment owned or controlled by the school, as well as personal effects left in those places and areas by students. This can be done without notice to or the consent of the student and without a search warrant. Illinois compiled Statutes 105-5-34-18.12. Inspection for drugs. The Board of Education has the authority to allow school officials to seek help from law enforcement for conducting reasonable searches of school grounds and lockers to look for illegal drugs. This includes using specially trained dogs to conduct the searches. References. As future administrators, how would you handle the following scenario? Scenario: a student, Jamie, reports that another student, Taylor, has been showing off a knife to friends during lunch. As the principal, you receive this information and decide to address the situation. Question: how do you assess whether there is reasonable suspicion to search Taylor's belongings? If a search is conducted, how would you go about with the proceedings? Thank you for your time.